Hello students, welcome and good afternoon. Well, in today's lecture, we are going to discuss yet another important topic of Indian polity, which is again a favorite topic for UPSC, and that is fundamental rights. Extremely important topic as far as UPSC is concerned in the context of both prelims as well as mains. Right? So in this lecture, basically we are going to discuss about what is the meaning and significance of fundamental rights, and we are also going to discuss about classification of the fundamental rights. There is three ways in which fundamental rights can be classified. There are three ways in which fundamental rights can be classified, and then we are also going to discuss about certain salient features of the fundamental rights, right? So let's begin. So first question, before we discuss what are fundamental rights or what is the meaning of fundamental rights, it is very important to understand meaning of the term rights. Because there are two words in the expression fundamental rights. That is, one is fundamental, another is right. So it is very important to understand what are rights. Okay? Now, in a simple words, rights can be called as claim of an individual over state, or against society, or against fellow individuals as well. Right? Now, why am I discussing meaning of rights? See, from last few years, UPSC is focusing on concepts. Whether it is prelims or mains, for example, in prelims, UPSC has asked questions such as, what is the appropriate definition of liberty? This was a question. What do you understand by liberty? What is the appropriate definition of liberty? And it had given 4 options. So you have to understand the concept of liberty, which most of the students, they ignore. So that is why I am discussing the concept of rights. Then UPSC has also asked the question on constitutionalism. What is constitutionalism? This year, they also are, this year in the sense last year in the prelims, they asked what is the appropriate definition of state. Okay? So UPSC is checking your conceptual clarity. Unfortunately, what students do is that they straight away take one book, one reference book, for example, Lakshmikant, and they will start reading the Lakshmikant. But in Lakshmikant, the concepts are not explained in a detailed manner. It is a very good book, but when it comes to conceptual clarity, you need to go beyond Lakshmikant. Right? So that is why I am discussing the concept of rights first, and then I'll discuss the concept of fundamental rights. So rights basically are claims. Right is a claim, or rights are claims of individuals against the state, or against the society, or against the fellow individuals. Right? Now, to be precise, rights are, not all claims can be called as rights. Rights basically are moral and social claims. Rights are moral and social claims. Rights are moral and social claims. Why they are social claims? Without existence of society, there cannot be a concept of rights. Rights are always enjoyed by the individuals in the context of society. And that is why rights are social claims. You cannot live your life in isolation. You have to be a member of a particular society. Then only your life will be meaningful. It is like a body, right? All the organs of our body, they have meaning and significance only in the context of entire body as a whole. If you take away your hand away from your body, if you take away your hand from your body, if you cut off your hand from your body, that hand doesn't have any meaning. So your hand has meaning only in the context of entire body. So similarly, individuals, they enjoy right only in the context of society in which they live. So rights are moral and social claims. Now, not all social claims can be called as rights. There might be innumerable social claims. Now, not all social claims are rights. It means that those social claims which are not recognized by the society, those social claims which are not recognized by the society, they will not be called as rights. So the social claims become rights. Social claims, they become rights only and only when, number one, they are recognized by the society. Society must recognize the social claims of the individuals. If society does not recognize that those social claims, then those rights those claims will be empty claims. Claims which are not recognized by the society, they will be called as empty claims. Because we as an individuals are part and parcel of society. Okay? So rights are social claims which are recognized by the society. Now, mere recognition of the social claims of the individuals by the society does not ensure that individuals will have rights. It means that there needs to be another condition which needs to be fulfilled in order to have a complete definition of rights. Now, in this context, remember that those social claims which are not enforced by the state, those social claims which are not enforced by the state, such social claims will be powerless claims. For example, there might be some social claims which are recognized in the society, but such social claims are not enforced by the state. It means that they are not backed by any law. So rights which are not backed by any law of the state, they doesn't have any meaning. So suppose you have social claim, and that social claim is recognized by the society, but that is not enforced by the state. It means that if some individuals, they violate such social claims or rights, then you don't have any remedy, because such social claims are not backed by the force of law. Understood? So rights are those social claims, number one, which are recognized by the society, and number two, which are enforced by the state. Got it? So this is the definition of, complete definition of rights. Write down. Rights are those, you can skip moral claims, right? Social claims, you can write moral claims as well, but rights are those social claims of individuals which are recognized by the society, recognized by the society in which individual lives, and enforced by the state. Mere recognition of rights by the society is not enough. Along with recognition of a particular right by the society, enforcement of that right by the state is also important. Society might recognize you have right to marry to a person whichever you want, but if your right to marry your right to marry or your right to choose your partner, it is recognized by the society, but it is not backed by the law of the state, passed by parliament or state legislature, then that law will remain, that right will remain only on paper. You will not have any remedy if someone violates your right. So that is why enforcement of that right by the state is very, very important. And how state enforce that law? How state enforces your laws? State enforces your law by prescribing certain punishment to those who violates your rights. Okay? Got it? The concept of rights. Rights are social claims. But not all social claims are rights. Social claims which are not recognized by the society are empty claims. So social claims become rights only when they are recognized by the society. But this is not enough. Now those social claims which are not enforced by the state, they are powerless claims. They will remain only on paper, or they will remain in the society, but you will not enjoy that effectively. It is as if I have 10 rupees in my pocket, but I can't spend it. So does that have any meaning? Your 10 rupees, you have 10 rupees, but you can't spend. You don't have right to spend that. So that is why, along with recognition of the social claims of the individuals, enforcement of such social claims by the state is also important. So you might get a question, what is the most appropriate definition of rights? Number 1, moral claims. Number 2, natural claims or natural rights. Number 3, social claims of individuals which are recognized by the society. Third option. Fourth option, social claims of the individuals which are recognized by the society as well as enforced by the state. This becomes the complete definition of rights. Please remember this definition. Clear? Hai? Recognition of social claims by the society as well as their enforcement by the state is very, very important. Without that, without any one of them, the rights are meaningless. Both should exist at the same time. Recognition by the society and enforcement by the state, this condition should be fulfilled simultaneously. For example, there might be rights which are enforced by the state, but they are not recognized in the society. Then such rights will only remain on paper. For example, now Parliament has decriminalized homosexuality. Sorry, not Parliament. The Supreme Court has decriminalized the homosexuality. But many people in the society, they do not recognize this. So this right has remained only on paper. People have fear to openly claim that they are homosexuals, right? So recognition of society is also important. So triple talaq has been criminalized by the Parliament. But there are many orthodox women, they do not recognize, they do not, or many sections of Muslim society, they do not recognize this. They still follow triple talaq. So does this law has any meaning in real sense of the term? No. So recognition of the society as well as enforcement by the state, both are equally important. Both are complementary and supplementary of each other. So any social claim, in order to be called as rights, it must be recognized by the society and enforced by the state. Got it clear? No confusion? Great, very good. Now, we have seen that rights should be enforced by the state. Meaning they should have a backing of law. They should have legal backing. Legal backing. If you violate traffic rule, suppose you have right to private property, and suppose some thief comes and he takes away your property, then you should have some remedy. You can go to the court or you can go to the police station, you can file an FIR, and if the thief is catch, he will be punishment by law. Right? So rights should have legal backing. So rights, in the sense, they are legal rights. Legal rights. Only those rights which are backed by the law, or only those rights which have legal sanction, by the state, only they are effective or they are meaningful. There might be rights which are not backed by the law, but so the such laws, such rights, will they have any meaning? No. Okay? So most of the rights, if rights in order to become effective, they should be backed by law. Such rights which are backed by legal sanction or legal force, they are called as legal rights. Okay? Legal rights. Now let us discuss the difference between constitutional rights and legal rights. Okay? Difference between constitutional rights and legal rights. Now what is the Constitution? I told you in the beginning itself, in the beginning lecture. Okay? Now Constitution is a legal document having legal sanctity, which represents the aims, goals, vision and aspirations, etc. of the people as a whole. That is what Constitution is. But Constitution is a legal document. Constitution is also a legal document. It is also a law. But it is the supreme or fundamental or paramount law of the land. Constitution is also a law, but it is supreme, it is fundamental law, or it is a paramount law of the land. All other laws in a country, they are inferior as compared to the Constitution. Got it? Okay? So in that sense, and what are the legal rights? Legal rights are those which are backed by law. So in this sense, all constitutional rights are legal rights. Yes? All constitutional rights are legal rights, because Constitution is also a legal document. But is the contrary of this statement true? Can we say that all legal rights are constitutional rights? No. So what are constitutional rights? Constitutional rights are those rights which are enshrined in the Constitution itself, which is the supreme, fundamental, paramount law of the land. What are constitutional rights? What are constitutional rights? Constitutional rights are those rights which are derived not from the ordinary law of the parliament or a state legislature, which is derived from the text of the Constitution itself. Write down this. Constitutional rights are those rights. Constitutional rights are those rights which are enshrined in the Constitution itself. Yes? Enshrined means mentioned or derived from the Constitution itself. And Constitution is a legal document having legal sanctity, which represents the goals, ideals and visions of the people as a whole, right? That is what Constitution is. That is what we have seen. So all the constitutional rights are legal rights, because Constitution is a legal document. But can we say that all legal rights are constitutional rights? Can we say this? Can we say this? Is it true? No, it is not true. For example, in India, every citizen has right to information. Now, right to information is a legal right. Why? Because it is backed by Right to Information Act 2005. So, right to information is a legal right. But has the right to information been provided explicitly in the Constitution of India? Explicitly. Directly likha hua hai, Article XYZ, right to information. Is it written? No. Yes, you can say that it is implicit under Article 19, Clause 1, Subclause A. But it is implicit. It is not explicitly mentioned. Similarly, right to work. It is a legal right under MG Narega Act, Mahatma Gandhi National Rural Employment Guarantee Act 2005, which provides a guaranteed employment of minimum of 100 days of work in manual unskilled, it should be a manual unskilled job, right? So, right to information, consumer rights, consumer protection rights, there is a Consumer Protection Act. So these are legal rights, but have these rights have the rights been mentioned in the Constitution? No. So all the legal rights are not constitutional rights. Clear? So let me write this sentence again. All constitutional rights are legal rights. But all legal rights are not necessarily, they may or may not be, they may or may not be, see, this is very important. Not necessarily. All the constitutional rights are legal rights, but all legal rights are not necessarily or compulsory constitutional rights. They may, all the legal rights may be constitutional rights, or they may not be constitutional rights. So all the legal rights are not necessarily constitutional rights. So this completes our discussion. Difference between constitutional rights and legal rights. Now there is one more difference. Now I told you that constitutional rights are those rights which are derived from the Constitution itself, which are mentioned in the Constitution itself, which are enshrined in the text of the Constitution itself. Now, constitutional rights, they can be abridged, they can be curtailed, or they can be taken away by the Parliament only by passing Constitutional Amendment Act under Article 368. So Parliament can take away, Parliament can curtail, Parliament can limit the constitutional rights of the citizens. I am talking in context of India. Okay? In India, the constitutional rights, they can be taken away by the Parliament, they can be curtailed by the Parliament, they can be limited by the Parliament, but not through the ordinary legislative process, not through ordinary law, which requires only simple majority, but through amendment to the Constitution passed under Article 368, which requires special majority. But what about legal rights? If Parliament has provided Right to Information Act under Right to Information under Right to Information Act 2005. Now Parliament decides one day that right to information is creating so much of obstacle in the governance. There are so many false and vexatious cases of right to information application. The right to information application are merely filed to impede the governance. Then suppose Parliament decides to repeal Right to Information Act of 2005. What Parliament will need? Parliament will only need simple majority. It can do so only by ordinary law, or by passing ordinary law. Right to Information Repeal Act. So legal rights can be taken away merely through ordinary legislative process. They can be taken away in the same manner the ordinary laws are made. And ordinary laws are made through simple majority. That is, majority of not less than half of the members present and voting in each house. But can constitutional rights be taken away by simple majority? No. So when it comes to legal rights, constitutional rights are superior. They have more protection. They cannot be taken away by Parliament through ordinary legislative process. Parliament has to pass the Constitutional Amendment Act under Article 368, which requires special majority. This is what is the difference between constitutional rights and legal rights. Got it? All the constitutional rights are legal rights, but all the legal rights are not necessarily constitutional rights. They may or they may not be constitutional rights. Okay? For example, in India, right to work, Forest Rights Act, Forest Rights is a legal right under Forest Rights Act 2006. It is not a constitutional right. Okay? So not all legal rights are necessarily constitutional rights. तो ये necessarily लिखना जरूरी है, not necessarily. They may or may not be. ऐसा भी हो सकता है किसी कंट्री के कॉन्स्टिट्यूशन में सारे लीगल राइट्स कॉन्स्टिट्यूशन में ही लिख दिए. So in that case, all legal rights will become constitutional rights. So all the constitutional rights are legal rights, but all the legal rights are not necessarily constitutional rights. They may be, all legal rights may be constitutional rights, but they may not be constitutional rights. Got it clear? Two differences. Constitutional rights can be taken away through special procedure, through special majority of the Parliament, whereas legal rights can be taken away through ordinary legislative process, through simple majority of the Parliament in the context of India. Okay, got it? Very good. So difference between constitutional rights and legal rights. Now, within the constitutional rights, within the Constitution, there might be some rights which might be kept at a superior level, and some rights, they, as compared to some rights, they might be at an inferior level. So how can we classify constitutional rights? So we have constitutional rights. So some constitutional rights, they can be very important. They can be fundamental. And there might be other constitutional rights. Constitutional rights can be classified into fundamental rights and other constitutional rights. Now I will discuss what are fundamental rights. Constitutional rights can be classified into fundamental rights and other constitutional rights, या फिर non-fundamental rights. But instead of using non-fundamental rights, use other constitutional rights. The term constitutional should be mentioned because they are mentioned in the Constitution itself. Okay? Fine. Now, what are fundamental rights? What are fundamental rights? What is happening here? There is, I think, some problem with the board. Fundamental rights. First, I will discuss fundamental rights, and then I will discuss other constitutional rights. And I will discuss the comparison, difference between fundamental rights and other constitutional rights. The way I discuss the difference between constitutional rights and legal rights. Okay? Now, fundamental rights are those rights. In the context of India, this entire discussion is in the context of India. Fundamental rights are those rights which are enshrined in Part 3 of the Indian Constitution from Articles 12 to 35. Fundamental rights are those rights which are enshrined, which are mentioned in Part 3 of the Indian Constitution, which contains articles from Article 12 to Article 35. Remember, the chapter Part 3 or a chapter on fundamental rights starts from Article 12 and it ends on Article 35. But the actual fundamental rights, they start from Article 14. Article 12 is about definition of state. Article 13 we have already discussed in the context of basic structure doctrine. State shall not make any law that takes away or abridges any of the fundamental rights, and any law made in contravention of this particular rule shall be, to the extent of such contravention, be declared null and void. Article 13. So actual fundamental rights start from Article 14, but the chapter 3 or Part 3 of the Indian Constitution contains Articles 12 to 35. You cannot say Article 14 to 35. That's absolutely wrong. Okay? And the last fundamental rights mentioned is Article 32. But still it ends on 35 because there are other provisions. Okay? Right? So fundamental rights are those rights which are enshrined in Part 3 of the Indian Constitution from Articles 12 to 35. So only those rights which are mentioned in Part 3 will be called as fundamental rights. What about other constitutional rights? Other constitutional rights are those rights which are mentioned in the Constitution but outside Part 3 of the Constitution. What are other constitutional rights? ये समझ में आया fundamental rights क्या है? So what are the other constitutional rights? Other constitutional rights. Other constitutional rights. Yeah, non-fundamental rights. Now, other constitutional rights are those constitutional rights. Those constitutional rights. Those rights which are enshrined in the Constitution, but where? But outside the Part 3 of the Constitution. Got it? So both fundamental rights and constitutional rights, other constitutional rights, both fundamental rights and other constitutional rights, they are directly mentioned in the Constitution. But the difference in where they are mentioned. If constitutional rights are mentioned in the Part 3, then such constitutional rights will be called as fundamental rights. And if such rights are mentioned outside the Part 3 of the Indian Constitution, they will be called as other fundamental rights. Got it? Fundamental rights, constitutional rights can be classified into fundamental rights and other constitutional rights. I have told you. Okay. Yes. Yes, this is it. Constitutional rights can be classified into fundamental rights and other constitutional rights. And I have told you what are fundamental rights, I have told you other constitutional rights. So what are the examples of fundamental rights? Give me any example of fundamental rights, you must know that, right? Right to equality. Right to equality from Article 14 to 18. It is mentioned in Part 3 and that is why it is fundamental right. Right? Then right to freedom of speech and expression mentioned in Part 3, fundamental right. Right to life and personal liberty mentioned in Part 3, That is why fundamental rights. Right? So I'm going to tell you what are the fundamental rights, or what is the classification of fundamental rights. At that time you will know what are the fundamental rights. Okay? Let us discuss about what are the other constitutional rights, and then I'll go back to our discussion on fundamental rights. Okay? Remember, this is not mentioned in the Lakshmikant. Lakshmikant only has factual details. What I told you. Hello Ravi. What I told you. Other constitutional rights are those rights which exist outside Part 3 of the Indian Constitution. They are mentioned in the Constitution. Right? That is why they are constitutional rights. But they exist outside the Part 3 of the Indian Constitution. Now can you give me any example of other constitutional rights? Any example? Socho? Right to property. Absolutely correct. Okay? Right to property. What else? I'm going to discuss the history of right to property. Initially it was a fundamental right. Then later on it was transformed as a constitutional right. Okay? So let me give you example of other constitutional rights. Okay? First, right under Article 265. It states that no tax shall be levied or collected except by authority of law or under authority of law, one and the same. This is also other constitutional right. Right not to be taxed. Right not to be taxed except authority of law. पार्लियामेंट ने लॉ पास करना है तभी जाके वो कोई टैक्स लेवी या कलेक्ट कर सकता है. समझ में आया? दिस इज अ अदर कॉन्स्टिट्यूशनल राइट अंडर आर्टिकल 265. ठीक है? फर्स्ट एग्जांपल. सेकंड, as you guys rightly pointed out, article 300A, right to property. No person shall be deprived of his right to property except by authority of law, save by authority of law. Okay? It is mentioned in 300A. Outside Part 3. 300A is under Part 12. It is outside Part 3 and that is why it is other constitutional right. ये हो गया एक. और एक बताता हूं मैं आपको. लिख लो ये सारे examples. Then right under Article 301. It is about freedom of trade. Freedom of trade, commerce and intercourse throughout the territory of India. So you have freedom of trade and commerce and intercourse throughout the territory of India, and that is your constitutional right. It is not a fundamental right, okay? Because it is mentioned outside Part 3. Now another important right which many students they ignore, that is right to vote. Yes, who is this? Then right under Article 326. Article 326. Article 326 states that elections to House of the People and legislative assembly of states shall be on the basis of adult suffrage. On the basis of adult suffrage. So Article 326 provides that all the citizens of India who are not less than 18 years of age, they will have right to vote. They will have right to vote. यार पानी देना, ठीक है? So right to vote is other constitutional right. ठीक है? Let me have. Yes, Shadruddin, you are right. Article 265. Right to vote is a constitutional right. It is not a fundamental right, but it is a constitutional right because it is mentioned under Article 326 of the Indian Constitution. All the citizens who are not less than 18 years of age, they shall be right to vote. They shall enjoy right to vote in elections to the House of the People and Legislative Assemblies. Now, what about right to be elected? What about right to be elected? Right to vote हो गया. What about right to be elected? Yes, it is also a constitutional right. Both right to vote and right to be elected, both are constitutional rights. ठीक है? Right? You can mention Article 325 as well. No person's name shall be excluded in the electoral roll on the basis of religion, race, caste, and sex. Right? Non-discrimination in inclusion of name of a person in electoral roll, name of a citizen in an electoral roll. Okay? So these are all the examples of other constitutional rights. What are they? What are they? Yes. कौन से? Let me write it here. Example of other constitutional rights. Article under which these other constitutional rights are mentioned. Article 265. Article 300A. Article 265, no tax shall be levied or collected. Yes, what? उसमें 256 बोला था? No. It was 265. 256, no. Article 265 समझ में आया? Other constitutional rights. Article 300A, right to property. Right to property is constitutional right. It is not a fundamental right. Originally, right to property was a fundamental right. Under Article 19 clause 1 subclause F and under Article 31. But 44th Constitutional Amendment Act 1978, it basically converted the right to property from fundamental right to other constitutional right by keeping it under Article 300A in Part 12. Okay? Then another example, another other constitutional right, 301. 301. आपको क्वेश्चन आ सकता है, व्हाट आर द फॉलोइंग राइट्स आर एग्जांपल्स ऑफ अदर कॉन्स्टिट्यूशनल राइट्स. इसमें ये सारे हो सकते हैं, तो यू शुड नो आर्टिकल 365, 265, you should know Article 300A, you should also know Article 301. Then right to vote and to be elected. These are all examples of other constitutional rights. समझ में आया? And why there are other, all of them are mentioned outside Part 3 of the Constitution, but they are mentioned in the Constitution. समझ में आया? अब यूपीएससी में 2017 में एक क्वेश्चन आया था 2017 में, and this question created a lot of, there was a lot of controversy many coaching institutes, they released the key which gave wrong answer. Why? The question was, right to vote and to be elected is option A. Option A was fundamental right. Okay? Option A was fundamental right. And this was in 2017 UPSC prelims. Option B, natural rights. Natural right. Option C, constitutional rights. And option D, legal right. This was exactly the question UPSC asked in prelims 2017. Right to vote and to be elected is. Now, the controversy or debate was around these two options. Right to vote is not a fundamental. Right to vote and to be elected is not a fundamental right because it is not mentioned in Part 3 of the Indian Constitution. As simple as that. It is not a natural right. Right? It is not a natural right. Natural rights are those rights which are enjoyed by the individuals in the state of nature. Some rights which are natural to the individuals. Okay? Right? So natural rights are merely a social claim. But I told you, rights in social claim, in order to transform into rights, they must be recognized by the society and enforced by the state. So that is why this is wrong answer. That is why it is very important to understand concepts. Now the question is, see, in simple words, right to vote and to be elected is a legal right. Definitely it is a legal right. Yes. Why? Because it is mentioned in the Constitution, which is a legal document. But there is another option, constitutional right. What are constitutional rights? Constitutional rights are those rights which are mentioned in the Constitution itself. Is right to vote mentioned in the Constitution? Is right to be elected is mentioned in the Constitution? Yes, it is. It is. Can you prohibit any citizen from contesting elections if he fulfills all the conditions? No. You cannot. So yes, it is a constitutional right. Okay? So the correct answer is constitutional rights. Many coaching institutes, they gave this option D as correct. But then 1 year after UPSC released the key, and the answer was constitutional rights. And based on our discussion also, I've told you, right to vote is a constitutional right because it is mentioned in the Constitution. Yes, it is there. It is legal right. We are not saying that it is legal right. But when two options are given, or when two options are closed, we have to choose most appropriate option. In this context, the most appropriate answer is constitutional right. Yes, what is your question? Yes, obviously, yes, yes. C and D both. Definitely. Obviously, yes, obviously. Agar ye na, consider the following statements. Right to vote and to be elected is statement 1, fundamental right, statement 2, natural right, statement 3, constitutional right, statement 4, legal rights. Which of the following options are correct? A mein aayega A only, B only, C only, C and D both. The answer is C and D both. Absolutely. Okay? But this question has already been asked, so UPSC is not going to repeat this question. Just remember, right to vote and to be elected in India is a constitutional right because it is mentioned in the Constitution itself. समझ में आया? Fundamental rights and other constitutional rights can be classified into fundamental rights and other constitutional rights. Now, what is the difference between fundamental rights and other constitutional rights? I'll tell you only one difference which is very significant. If the fundamental rights of the citizens are violated, citizens or non-citizens, because there are certain fundamental rights which are available to non-citizens as well. So let me use the word individual. If the fundamental rights of the persons or individuals are violated, then they can directly approach the Supreme Court for their enforcement. If fundamental rights of the individuals, citizens or non-citizens, whatever it may be, as per the case, then individuals can directly approach the Supreme Court, not necessarily by way of appeal from the judgment of high courts. So if your fundamental rights are violated, you can directly go to the Supreme Court. But when it comes to the other constitutional rights, you cannot directly approach the Supreme Court. You have to approach High Court first, and then only you can appeal against the judgment of High Court. So when it comes to other constitutional rights, fundamental rights have been given more protection. They are superior as compared to other constitutional rights. समझ में आया? If fundamental rights are violated, then you can directly approach the Supreme Court, not necessarily by way of appeal from the judgment of High Court. आपको अगर कोई केस फाइल करनी है तो आपको पहले सबऑर्डिनेट कोर्ट में जाना पड़ेगा, फिर सबऑर्डिनेट कोर्ट अपना जजमेंट देगा, डिस्ट्रिक्ट कोर्ट और सबऑर्डिनेट कोर्ट, फिर उसके जजमेंट के अगेंस्ट आप अपील करोगे, फिर हाई कोर्ट में जाओगे, फिर हाई कोर्ट के जजमेंट से अगर आप खुश नहीं हो तो आप सुप्रीम कोर्ट में अपील करोगे. This is what is the normal legal process in India. But in case of fundamental rights, you can bypass the judicial hierarchy and you can directly approach the Supreme Court. But in case of other constitutional rights, you cannot directly approach the Supreme Court. You have to first approach the High Court, and you can approach the Supreme Court only through appeal against the judgment of High Courts. This is the difference between fundamental rights. This is the key difference between fundamental rights and other constitutional rights. समझ में आया? Now suppose your right to property is violated. Can you go directly to the Supreme Court? You have to first go to the High Court. If your freedom of speech and expression is violated, can you directly go to the Supreme Court? Yes, it is a fundamental right under Article 19, Clause 1, Subclause A. Got it? ठीक है? Fundamental rights and other constitutional rights. Difference समझ में आया? दो difference है. Fundamental rights are those rights which are mentioned or enshrined in Part 3 of the Indian Constitution. Other constitutional rights are those rights which are mentioned in the Constitution but outside Part 3 of the Constitution. And if fundamental rights are violated, you can directly approach the Supreme Court. Here, if other constitutional rights are violated, you have to first approach the High Court, and then only you can approach the Supreme Court against the judgment of High Court. समझ में आया? Very good. चलो, now let us go back to our discussion on fundamental rights. Classification समझ में आया? So we started with definition of rights. ठीक है? Then I told you about legal rights. Then I told you about constitutional rights. Then classification of constitutional rights into fundamental rights and other constitutional rights. And I gave you examples of fundamental rights as well as other constitutional rights. And we have compared. Then we have also compared legal rights and constitutional rights. ठीक है? समझ में आया? Very good. चलो. Now fundamental rights. Now yes, Pavitra Kumar, you're right, constitutional right. I forgot to read your comment. Anyways, now I told you that fundamental rights are enshrined in Part 3 of the Indian Constitution, which contains articles from 12 to 35. First. Okay? And these fundamental rights, from where the fundamental rights from where the Indian Constitution draw its inspiration, of incorporating the fundamental rights in the Constitution? From where? Can you answer? From the Constitution? What? No. I'm asking about, I already discussed the background of Constituent Assembly and salient features of the Constitution. I told you that there are certain provisions of the Indian constitutions, they are borrowed from other constitutions. Yes, so the question is, fundamental rights. The fundamental rights in the Indian constitution, they draw their inspiration from the Constitution of USA through Bill of Rights. Bill of Rights of USA. Bill of Rights of US Constitution, which is the oldest constitution in the world. When it came into force? 1789. So, fundamental rights in Indian constitution, they draw its inspiration from Bill of Rights of US Constitution. Okay? What is Bill of Rights? Bill of Rights include first 10 amendment to the US Constitution. As simple as that. The original US Constitution did not incorporate fundamental rights. They were incorporated through Bill of Rights. What is Bill of Rights? अगर किसी ने पूछा आपको, UPSC पूछ भी सकता है, what do you understand by Bill of Rights? So Bill of Rights means first 10 amendments to the US Constitution. Okay. While discussing UPSC GS paper 2 Indian polity question mains this time, there was a question on comparison between right to equality in Indian Constitution and US Constitution. I told you that right to equality was mentioned in the original Indian Constitution itself. It was not incorporated through constitutional amendment, but right to equality in USA was not there in the original US Constitution. It was incorporated through 14th Constitutional Amendment Act, which is a part of Bill. But that is not a part of Bill of Rights. What is Bill of Rights? Bill of Rights means first 10 amendments to the Constitution of USA. First 10, not 14th. Okay, right? Just remember this. Okay, first Bill of Rights means Bill of Rights include first 10 amendment to the Constitution of USA. As simple as that. Thank you, Sushmit. समझ में आया? ठीक है? Good. So, fundamental rights in Part 3 of the Indian Constitution, they have drawn or they draw their inspiration from Bill of Rights, that is first 10 amendments to the US Constitution. ठीक है? Simply they have derived their inspiration from Constitution of USA through Bill of Rights. ठीक है? समझ में आया? Very good. Now, why fundamental rights are called as fundamental? It's very important to understand why fundamental rights are fundamental. हमारे कॉन्स्टिट्यूशन में सिर्फ राइट्स क्यों नहीं लिखा है? कॉन्स्टिट्यूशन में पार्ट 3 में सिर्फ राइट्स का चैप्टर होता. व्हाई फाउंडिंग फादर्स यूज दिस टर्म फंडामेंटल? I told you not all rights can be fundamental rights, no? Not all rights are fundamental rights in India. Only those rights which are mentioned in Part 3 of the Indian Constitution, they are fundamental rights. As simple as that. Okay? Right? Now, fundamental rights are fundamental because of two things. There are two reasons. Number one, fundamental rights are fundamental in the sense that they are guaranteed and protected by the Constitution of India, which is the fundamental law of the land, which is the supreme law of the land. Fundamental rights are named fundamental rights in the sense that They are guaranteed and protected by whom? By the Constitution. Constitution is the fundamental law of the land. Okay? So fundamental rights are fundamental in the sense that they are protected and guaranteed by the Constitution of India, which is the supreme, paramount and fundamental law of the land. Second, this was the first reason, I already told you. Second reason, fundamental rights are fundamental in the sense that they are most essential. They are most essential for all-round development of human personality. Because they are guaranteed and protected. ये लिखा ऊपर का, they are guaranteed and protected. There might be a question, why fundamental rights are called as fundamental rights? Guaranteed and protected by the Constitution, which is the fundamental law of the land. And second, why? Because these fundamental rights are most essential for all-round development of personality. That is material, in economic sense, material, intellectual, moral and spiritual development of individuals. Now, why do we need fundamental rights? Fundamental rights, every individual should have certain sets of fundamental rights. Why? Because fundamental rights are absolutely essential for all-round development of human personality. Fundamental rights are essential for material, intellectual, moral and spiritual development of human personality. Individuals cannot attain their fullest potential without enjoyment of certain sets of fundamental rights. Can you enjoy your fullest potential without freedom of speech and expression? Can you? No. Can you enjoy your fullest potential, or can you ensure your all-round development of personality without right to life and personal liberty? No. So fundamental rights are those rights which are most essential for an individual to develop their fullest personalities. Fundamental rights are essential for an individual to attain his or her fullest potential. So without fundamental rights, without enjoyment of certain sets of fundamental rights, individuals will be incomplete. Individuals cannot attain their fullest potential. Lasky was a political philosopher. He said that rights are those conditions of human life without which no individual can be at his best. You can be at your best, meaning you can achieve your fullest potential only if you enjoy certain sets of fundamental rights. समझ में आया? So fundamental rights are called as fundamental in the sense, number one, because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. And second, because they ensure, they are most essential for all-round development of human personality. Be it material means economic terms, okay? Intellectual, freedom of speech and expression is very important for intellectual development. Right to form associations, unions, freedom of profession, it is very important for material growth, material development, intellectual. Okay? It should be, this is spelling डबल एल, ठीक है, इट शुड बी डबल एल, इंटेलेक्चुअल, मॉरल, स्पिरिचुअल, फ्रीडम ऑफ रिलीजन, इट इज वेरी इंपॉर्टेंट फॉर स्पिरिचुअल एंड मॉरल डेवलपमेंट ऑफ ह्यूमन पर्सनैलिटी. समझ में आया? ठीक है. सो वी नीड, व्हाई डू वी नीड फंडामेंटल राइट्स, उसमें लास्ट पॉइंट आएगा. व्हाई डू वी नीड fundamental rights? What is the purpose of fundamental rights? Can we live without fundamental rights? Why founding fathers of Indian Constitution, they incorporated fundamental rights in part 3 of the Indian Constitution? Why? Because they knew that there are certain sets of rights which are most essential for all-round development of human personality. There are certain sets of rights which are essential for individual to attain his fullest potential, his or her fullest potential, to bring his best, his or her best. है कि नहीं? So individuals are incomplete without fundamental rights. Individuals cannot attain their fullest potential. They cannot achieve their goals and objectives of their life without fundamental rights. This is the first purpose. This is the first reason why citizens should have fundamental rights. Okay? Now what else? First is all-round development. All-round development of human personality. Remember, this is very important discussion because UPSC might ask question. Fundamental rights is a favorite topic of UPSC. So what students do, they keep on repeating and mugging up the articles. What is Article 12? What is Article 13? What is Article 14? And UPSC will suddenly ask the question on concepts. That is why I am discussing this. Okay? Right. Now, second reason behind enjoyment of fundamental rights is to ensure limited government. Or the second important purpose of fundamental rights is to limit the powers of the government. See, fundamental rights basically protect, fundamental rights protect the rights and liberties of the individuals against invasion or violation by the state. Now, fundamental rights acts as a limitation on the power and authority of the government. How they act as a limitation on power and authority of the government? Can state take away your fundamental rights? No, in real sense, in theoretical sense of the term. No. Right? So, fundamental rights are essential to impose certain limitations on the power and authority of the government. Why they are essential? To impose, to ensure limited form of government. How can you ensure the limited form of government? By imposing limitations on power and authority of the state. So can executive, legislature and judiciary violate the fundamental rights of the citizens? No, it cannot. So fundamental rights acts as a limitation on the powers of the state and its three branches: executive, judiciary and legislature. Can parliament passes any law that takes away the fundamental rights? No, it can be challenged in the Supreme Court. Okay, right? But it doesn't mean that fundamental rights cannot be amended. In basic structure doctrine, we have discussed that Parliament has power to amend the Constitution, including the fundamental rights, under Article 368 of the Indian Constitution. But any amendment to the fundamental rights should not destroy, should not abridge, should not violate basic structure of the Indian Constitution. That is what basic structure is all about. Okay? So fundamental, another purpose, that was a positive purpose, right? Fullest development of human personality. But fundamental rights also serve negative purpose. Why? Fundamental rights are negative in nature. Why they are negative in nature? Because they act as a limitations on the power of the government. Fundamental rights prevents the state from doing something, that is, from violating the rights, fundamental rights of the citizens. So another purpose of fundamental right is to limit the powers and authority of the government and its various branches, namely legislature, executive, and judiciary. The main purpose of fundamental rights basically is to protect the rights and liberties of the individuals from invasion by the state, from violation by the state. So, fundamental rights, see, there is always a trade-off. There is always a trade-off between rights of the individuals and power and authority of the state. If power and authority of the state increases, the rights and liberties of the individuals, they decreases. So there is always a trade-off, negative relationship between rights of the individuals and power and authority of the states. Why? Because fundamental rights seeks to limit the power and authority of the state. Now tell me why it is very important to ensure limitations on the power of government or the state. Why it is important? Because Lord Acton once famously said, power corrupts and absolute power corrupts absolutely. So government has power, so there is a possibility, there is a high possibility that those who are in power, those who are part of government, they might use their power and authority in an arbitrary and whimsical manner. And if government exercises its power in an arbitrary and whimsical manner, then that government will become authoritarian government. That rule will be despotic rule. So the aim of fundamental rights is to prevent the government from using its power in an arbitrary and whimsical manner. क्या पुलिस ऑफिशियल, हम लोग अभी यहाँ पे बैठे हुए हैं, क्या पुलिस ऑफिशियल आके हम लोग को बिना कोई वजह अरेस्ट कर सकते हैं? और अगर उन्होंने किया तो क्या ये आर्बिट्ररी एक्सरसाइज ऑफ पावर नहीं है, विम्सिकल एक्सरसाइज पावर नहीं है? बिल्कुल है. And I have a fundamental right. We are discussing, it is a freedom of speech and expression. I am teaching you. And that is my fundamental right guaranteed in the Constitution. So someone cannot enter and arrest me unless and until I say something which is against the sovereignty of India or which incites violence. Right? But apart from that, you cannot. Right? So purpose of fundamental rights is to impose certain limitations on the power and authority of the state so that state does not uses its power and authority in an arbitrary, unjust and whimsical manner. So the basic aim of fundamental rights is to ensure political democracy, to achieve the ideals of political democracy. So fundamental rights ensure limited government. What is limited government? Limited government means constitutional government. UPSC asked this question. Constitutional government is a government whose powers are limited by the rights and liberties of the individuals. Constitutional government is a government whose powers are limited by the rights and liberties of the individuals. Okay? So to ensure constitutionalism, one of the important requirements is granting certain sets of fundamental rights to the citizens. Why? Because the basic purpose of fundamental rights, along with full all-round development of human personality, is to impose certain limitations on the powers and authority of the government, to prevent the government from using its power and authority in an arbitrary, despotic, authoritarian and whimsical manner. So in that sense, fundamental rights ensures the ideal of political democracy. Fundamental rights acts as a defense of rights and liberties of the citizens from its invasion by the state. समझ में आया बेसिक पर्पस? ठीक है, फर्स्ट पर्पस इज पॉजिटिव पर्पस, that is all round development of human person. Second purpose is a negative purpose, that is to limit the powers of the state, to prevent the state from using its power and authority in an arbitrary, whimsical, authoritarian and despotic manner. So fundamental rights prevent authoritarian or despotic rule. Yes, fundamental rights prevent authoritarian, arbitrary and despotic rule. Prime Minister of India cannot do anything the way he wants. Ruling party cannot arrest the members of opposition political party just because they are in opposition or they oppose the policies of the government. Why? Because they have fundamental rights. Okay? And while discussing about the concept of the difference between I have discussed about the principle of parliamentary supremacy in Britain. The parliamentary supremacy is a principle followed in UK, because in UK it is the parliament that is supreme and not the constitution, whereas in USA it is the USA constitution is based on the principle of judicial supremacy. In USA, judiciary is supreme. But in case of India, Indian constitution achieves the synthesis between the British principle of parliamentary supremacy and US principle of judicial supremacy. Unlike British parliament, Indian parliament is not supreme. Powers of Indian parliament are limited by 4 things I told you. Tell me. By number one. No, I told you about the judicial review. Bring those notes. निकालो वो notes. चार restrictions कौन से बताओ. Yes, number 1, fundamental rights of the citizens. Second, federal structure with a division of powers between center and state. Third, judicial review. And what was the fourth? Supremacy of the constitution. Indian parliament is not supreme. The supremacy of the Indian parliament is limited by, number 1, supremacy of the constitution. In India, it is the constitution that is supreme. Second, federalism, federal structure with division of power between state and center. Second. Third, judicial review. And fourth was fundamental rights. Fundamental rights, that is what we are discussing. Power of parliament are limited along with other factors, fundamental rights. Parliament cannot make any law that takes away or abrogates any of the fundamental rights. That is what is written in Article 13 Clause 2. That is what is written in Article 13 Clause 2. State shall not make any law that takes away or abrogates any of the rights conferred by Part 3. And any law made in contravention of this rule shall be, to the extent of such contravention, null and void. Okay, Priyanka, this is a English batch, but yes, I will be bilingual. समझ में आया? ठीक है, fundamental rights का purpose क्या है? Very good. Now, the part 3 of the Indian Constitution is rightly referred as Magna Carta of India. Magna Carta. What is Magna Carta? Again, go to the roots, understand the concept. Magna Carta, basically, it is a Latin term. It is a Latin term which means the Great Charter. The Great Charter. It's a document. Charter means document. Part 3 of the Indian Constitution is referred as Magna Carta of India. What is the meaning of the term Magna Carta? Magna Carta is a Latin term which means the Great Charter. Now, Magna Carta was a royal charter. Magna Carta was a royal charter. It was a royal charter issued by King John of England under the pressure from barons in 1215. This year is very important. 1215. What is Bill of Rights? First 10 amendments to the US Constitution. What is Magna Carta? Magna Carta was a royal charter issued by King John of England in 1215. Now, under the pressure from barons. Barons means noblemen, lords. है ना, feudalism था उस time पे, feudal society थी, feudal lords. So under the pressure from barons or feudal lords, King John, who had absolute powers, he was forced to recognize certain rights of English people. Now Magna Carta of 1215 is the first written document about rights of the citizens in the world. It is the oldest and the first document, written document, regarding rights of the individuals. It was issued in 1215. समझ में आया मैग्ना कार्टा क्या है? It is the oldest written document regarding rights of the individuals in the world. पहली बार through issuing Magna Carta in 1215, the state, King John, he recognized that yes, individuals do enjoy certain rights against the state. Because at that time, UK was absolute monarchy. Absolute monarchy is a monarchy in which monarch enjoys unlimited powers without no restrictions whatsoever. And this King John was very despotic ruler because his powers were not limited by any rights. So this was the first time he recognized that yes, individuals, they do enjoy certain rights against the state. Got it? Okay. So two things are important. Number one, the fundamental rights, the chapter on fundamental rights basically draws its inspiration from Bill of Rights of USA, which is the first 10 amendment to the US Constitution. Second, part 3 is rightly referred as the Magna Carta of India. And I told you about Magna Carta. Got it? Okay. Now, part 3 of the Indian Constitution consists of articles from 12 to 35. So part 3 is part 3 contains the very long list of comprehensive and elaborate rights. It is a very comprehensive and long list. In fact, part 3 of the Indian Constitution, it is the most comprehensive part across the world. Part 3 of the Indian Constitution contains so vast and elaborate rights which can be found nowhere in other constitutions, including USA. So part 3 in the Indian Constitution is extremely comprehensive and elaborate. Such elaborate and comprehensive list of fundamental rights cannot be found in any constitution across the world, including US Constitution. Got it? Okay, fine. Now let us discuss about, so I told you about the fundamental rights. Why do we need why fundamental rights are called as fundamental? Then I discuss why individuals should enjoy fundamental rights. Positive reason, negative reason. 2. Now, then I told you about the background. है ना, Bill of Rights क्या है, Magna Carta क्या है. Now let us discuss about classifications. Classification of fundamental rights. Now, fundamental rights can be classified in 3 ways. Okay? First way of classification is on the basis of on the basis of content or subject matter. Okay, right? Classification on the basis of content of the right, content of that particular right or subject matter of that right. Okay. Now on the basis of this, type of classification, fundamental rights can be classified into 6 categories. Number 1, right to equality from articles 14 to right to equality from article 14 to 18 on the basis of content. ठीक है यार ये 4 ऐसा क्यों आ रहा है 1 4 yes. Second, right to freedom from articles 19 to 22. Write down. Third, so on the basis of content or subject matter, right to equality content, right to equality है from article 14 to 18, right to freedom 19 to 22, right against exploitation, article 23 24, right article article ठीक है article 14 18, don't just write number 14, article ठीक है I am not getting space ठीक है article 23 24. अगर तुम सिर्फ नंबर लिखते हो, it doesn't have any meaning. What is 14? It can be anything. So adding word article is very important. Okay. Then fourth, a right to freedom of religion. Right to freedom of religion. Article 25 to 28. Fourth right. ठीक है? Yes. Then fifth, the most important right. No, not this. No, right. Sorry. Next is cultural and educational rights. Cultural and educational rights from articles. Cultural and educational rights. Cultural and which articles? Yes. From articles 29 to 30. 2 articles only. Okay? And last but not the least, and the most important fundamental right, Dr. Ambedkar called this right as heart and soul of the Constitution, and that is right to constitutional remedy. Article 32. Yes. So these are the 6 rights which are guaranteed by Part 3 of the Indian Constitution. Right to equality from articles 14 to 18, right to freedom from articles 19 to 22, right against exploitation from article 23 24, right to freedom of religion from articles 25 to 28, cultural and educational rights from article 29 to 30. Yes, Shiva, hi. Right to constitutional remedy, article 32. So Indian Constitution provides for six fundamental rights. 6 fundamental rights. But the original Indian Constitution provided for 7 fundamental rights. Along with these 6 fundamental rights, it's also included 7th fundamental right, that was right to property, which was a fundamental right under Article 19 clause 1 subclause F and Article which 31, ये याद रखना है. Original Indian Constitution provided for 7 fundamental rights, including right to property. But ये लिख लिया आपने? Yes, did you write it down? ठीक है. But right to property was removed from part 3. It was removed as a fundamental right and incorporated as other constitutional right by 44th Constitutional Amendment Act passed in 1978. This made a right to property as constitutional right under article, which article? 300A in part 12. And it repealed 2 articles, no, under which right to property was fundamental. Article 19 clause 1 subclause F, it is repealed now, and Article 31. If you read the Bare Act, it is mentioned that Article 19 clause 1 is repealed, Article 31 is repealed, by which ये भी question आ सकता है, which Constitutional Amendment Act repealed Article 19 clause 1 subclause F and Article 31, है ना? फिर इसीलिए आपको ये पता होना चाहिए, ठीक है, राइट? अगर आपको राइट टू प्रॉपर्टी की हिस्ट्री पता है, then only you will be able to answer. So these 2 articles are very, very important, and I have discussed these 2 articles when I discussed basic structure doctrine. Those who are watching online, please watch the lecture on basic structure and all other lectures. I have covered the topic comprehensively, okay? Got it? So this is the first type of classification, that is classification on the basis of on the basis of content or subject matter. First type of classification. Second type of classification, okay, right, is on the basis of availability. No, it should be small. On the basis of availability. Yes, very important. Now, under part 3 of the Indian Constitution, some fundamental rights are available to all, both citizens and non-citizens. But there are some fundamental rights which are exclusively available to citizens of India only. So on the basis of availability, the fundamental rights can be classified as those available exclusively to citizens only, and those available to both citizens and non-citizens. Non-citizens में क्या? Foreigners. अरे non-citizens के जगह पे foreigners भी लिख सकते हो. Non-citizens / foreigners. First way of classification was on the basis of content, six fundamental rights. Second, on the basis of availability, those fundamental rights which are available exclusively to, and those available to citizens only. ठीक है? Fundamental rights. चलो, now first fundamental rights available only or exclusively to citizens. Write down fundamental rights under articles 15, 16, 19, 29 and 30. 1, 2, 3, 4, 5. These fundamental rights are available to only citizens. They are not available to foreigners. Fundamental rights under article 15, 16, 19, 29, 30. Don't forget this. This is very important. What is article 15? I'm going to discuss all the articles in fundamental rights, but just for the sake of information, article 15, prohibition of discrimination only on the basis of religion, prohibition of discrimination on the basis only of religion, race, caste, sex, place of birth. Article 15. No citizen shall be discriminated. The word used under article 15 is citizen. See, you have to read articles very carefully. So you have to see whether the word mentioned is citizen or person. On the basis of that, we can say this. Article 16, right to equality of opportunity in matters of public employment. This is also available only to citizens. फॉरेनर्स को राइट टू इक्वलिटी इन एम्प्लॉयमेंट नहीं है. अगर यहाँ पे हमारे लोगों को ही जॉब नहीं है और फॉरेनर्स को आके यहाँ पे राइट टू इक्वलिटी इन मैटर्स ऑफ पब्लिक एम्प्लॉयमेंट होगा तो फिर हो गया. आर्टिकल 19 प्रोवाइड्स 6 फंडामेंटल राइट्स. ठीक है? एंड दिस 6 फंडामेंटल राइट्स आर available only to citizens. What are these 6 fundamental rights? Freedom of speech and expression, assembly, association, ठीक है, movement, residence and profession, trade, business. ठीक है? Freedom of speech and expression, association, assembly, association, movement, residence, profession, trade, business, occupation. 6 available only to citizens. Article 29 and 30, cultural and educational rights. Article 29 is about that, any section of Indian citizen having distinct language, script, culture have right to preserve the same. 29. Article 30, educational rights of minorities. They can establish educational institutions of their own. And state shall not discriminate against the minority educational institutions while giving grants or financial assistance. That is what Article 30 is. So these 5 fundamental rights are available exclusively to the Indian citizens. They are not available to foreign citizens. Can foreigners claim freedom of speech and expression in India as a fundamental right? No. समझ में आया ये 5 rights? ठीक है? And all other rights except this, all other rights except article rights under rights except fundamental rights under article 15, 16, 19, 29 and 30 are available to both citizens and foreigners. तो इसमें क्या आएगा? देखो, fundamental rights available fundamental rights available to both citizens and नॉन सिटीजन्स या फॉरेनर्स, जो आपको लिखना है, बट आई विल प्रेफर नॉन सिटीजन्स. ठीक है, राइट. आर्टिकल 14, ठीक है, 17, 18, 20, 21, 22, 23, 24, 25, 26, 27, 28, yes, 32. These are all available to citizens and non-citizens. इसमें interestingly, Article 20, right against conviction of offences. Article 21, right to life and personal liberty. Article 21 uses the word person. No person shall be deprived of his right to life and personal liberty except by authority of law. The word used is person. And that is why Article 21 is available to both citizens and non-citizens. Okay? UPSC has asked the question on this, that which are the fundamental rights are available to citizens only. याद करना है आपको. This is the second way of classification. Then third way of classification, third basis of classification is, is, देखो, let me write first on the basis of content और subject matter. इसमें हमने 6 देखे है ना classification, ठीक है. Second on the basis of availability. On the basis of availability. And third classification is on the basis of whether the fundamental right is self-executory or non-self-executory. ठीक है, right? Whether that fundamental right is self-executory fundamental right or non-self-executory fundamental rights. So it means that certain fundamental rights are self-executory fundamental rights and certain fundamental rights are non-self-executory fundamental rights. Let us understand what is self-executory fundamental rights. Now, self-executory fundamental rights are those rights which are capable of enforcement by themselves. I repeat, write down. Self-executory fundamental rights are those rights which are capable of execution by themselves without any subsequent law to be passed by the legislature. Self-executory fundamental rights are those fundamental rights which are capable of execution, or enforcement. self-executory fundamental rights are those rights which are capable of execution or enforcement by themselves without any subsequent law to be passed by the legislature. They are capable of self-enforcement. They are capable of self-execution. The enjoyment of such self-executory rights do not require any subsequent law to be passed by the legislature. For example, equality before law and equal protection of law under Article 14. This is an example of self-executory fundamental right, because it is capable of enforcement or execution on its own without any subsequent law to be passed by the legislature. कोई law pass करना पड़ेगा क्या पार्लियामेंट की? पार्लियामेंट ने कोई लॉ पास करना चाहिए राइट टू इक्वालिटी बिफोर लॉ और प्रोटेक्शन ऑफ इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ एंजॉय करने के लिए? नहीं. Right to equality before law and equal protection of law under Article 14, it is capable of self-enforcement. It is capable of execution or enforcement by itself without depending on any law to be passed by the parliament. समझ में आया? Right? Article 19. Article 19 guarantees 6 sets of fundamental freedoms. They are also examples of self-executory fundamental rights. Right? So, self-executory fundamental rights, they are complete rights. They are complete rights. You will understand self-executory fundamental rights when I will discuss non-self-executory fundamental rights. तब आपको समझ में आएगा. They are complete rights. Why? Because they are capable of enforcement, execution by themselves without any depending on any law to be passed by the parliament. कोई law के ऊपर dependent नहीं है वो right, fundamental right. ठीक है? So can you say that fundamental right to equality before law and equal protection of law can be enjoyed by all of us only if parliament passes any law? Can you say that? No, because it is self-executory fundamental rights. Now, I will discuss non-self-executory fundamental rights, and then you will understand the concept completely. Non-self-executory fundamental rights. Non-self-executory fundamental rights. Non-self-executory fundamental rights are those fundamental rights which are not capable. I am not writing the complete sentence. Just write down. Non-self-executory fundamental rights are those fundamental rights which are not capable of enforcement or execution on their own. Opposite to self-executory fundamental rights. Okay? Non-self-executory fundamental rights are those fundamental rights which are not capable of enforcement or execution on their own. Add correct sentence. Meaning to say they depend on subsequent legislation to be passed by the legislature. In the context of India, it is parliament. By the legislature for its enforcement. For its what? Enforcement. I will give you examples and then you will understand the complete concept. ठीक है? Sorry. ठीक है? Self-executory fundamental rights are those, non-self-executory fundamental rights are those fundamental rights which are not capable of enforcement or execution. It should be execution. कभी कभी मैं वो इसके चक्कर में इन द हीट ऑफ द मोमेंट एग्जीक्यूशन स्पेलिंग मिस्टेक होता है, तो आप प्लीज करेक्ट करो, ठीक है? कैपेबल ऑफ इन्फोर्समेंट और एग्जीक्यूशन ऑन देयर ओन, दे डिपेंड ऑन subsequent legislation to be passed by the legislature for its enforcement. They can, non-self-executory fundamental rights, they are not capable of self-enforcement or self-execution. They always depend on subsequent law to be passed by the legislature. In the context of India, it is parliament. Now let me give you example. Article 17. Article 17. What does Article 17 do? Article 17 states, Article 17 is about abolition of untouchability. Article 17 states that untouchability is abolished and its practice in any form is forbidden. I am quoting exactly the Article 17. Untouchability is abolished and its practice in any form is forbidden. Next sentence under Article 17. Enforcement of any disability arising out of practice of untouchability shall be an offense punishable in accordance with the law. Now, Article 17 is an example of non-self-executory fundamental rights. Why? Because it is not capable of its enforcement by its own. Why? Because in order to get enforced the fundamental right of untouchability, Parliament has to pass law. Article 17 says that practice of untouchability is abolished. And its the untouchability is abolished and its practice in any form is forbidden. Enforcement of any disability arising out of practice of untouchability shall be an offense punishable in accordance with the law. So Constitution of India has empowered the Parliament to enact a law to implement Article 17. तो जब तक पार्लियामेंट लॉ पास नहीं करता है तब तक क्या आप अनटचेबिलिटी का राइट एग्जीक्यूट कर सकते हैं उसको? कैन सिटीजंस क्लेम फंडामेंटल राइट्स? नो. नाउ लेट मी गिव इंटरेस्टिंग थिंग. सो दिस आर्टिकल 17 वाज इनकॉर्पोरेटेड इन 1950. नाउ it merely states that untouchability is abolished. It does not, Constitution of India under Article 17 does not prescribe any punishment if someone practices untouchability. Why? Constitution of India has empowered the Parliament to prescribe punishment for practice of untouchability. Now Parliament passed such law under Article 17 only in 1955. The law was known as Untouchability Offences Act 1955. ठीक है? Untouchability Offences Act, Untouchability Offences Act 1955, which was later renamed as, अभी इसको कहते हैं Protection of Civil Rights Act. इसको अभी इसका नाम है Protection of Civil Rights Act 1955. 1976 में इसका नाम चेंज किया गया एक्ट का. पार्लियामेंट ने लॉ कब पास किया? 1955 में. इट मीन्स दैट फ्रॉम 1950 till 1955 fundamental right under Article 17 was not capable of enforcement. So if it means that if someone would have practiced untouchability, he could have not been punished by the Supreme Court of India. Why? Because Supreme Court cannot punish any individual without existence of any law. सुप्रीम कोर्ट पनिशमेंट किस तरह से अवॉर्ड करता है? ऑन द बेसिस ऑफ सीआरपीसी, आईपीसी, ऑन द बेसिस ऑफ पार्लियामेंट्री लॉज, सो ऑन एंड सो फोर्थ. तो अगर 1950 और 1955 के बीच में अगर कोई व्यक्ति, दलित व्यक्ति जिसके अगेंस्ट अनटचेबिलिटी प्रैक्टिस की जा रही है, वो अगर सुप्रीम कोर्ट के पास जाता और बोलता कि देखो अनटचेबिलिटी इज माय अनटचेबिलिटी हैज बीन अबॉलिश्ड अंडर आर्टिकल 17, इट इज अ फंडामेंटल राइट ऑफ मी, प्लीज गिव मी सम प्रोटेक्शन, सुप्रीम कोर्ट would have been Supreme Court at that time was helpless. Why? Because Supreme Court cannot punish any individual without law. Supreme Court always interprets law, और law में जो punishment prescribe की है वही punishment, उसके हिसाब से कितना punishment देना है वो Supreme Court decide करता है. Parliament ने कोई law pass किया गया था क्या? नहीं. So it means that fundamental right under Article 17 was not enforceable till passage of Untouchability Offences Act 1955. Because it is an example of non-self-executory fundamental rights. वो कब enforceable हुआ? When fundamental right under Article 17 became capable of enforcement, only when Parliament passed this law. So the non-self-executory fundamental rights are those fundamental rights which depend on subsequent legislation passed by the Parliament for its enforcement. Without that, they cannot be enforced. That is why non-self-executory fundamental rights are incomplete fundamental rights. समझ में आया? Why they are incomplete? Because they are not capable of enforcement or execution on their own. They are always dependent on the subsequent law to be passed by the Parliament. So let me give you examples of non-self-executory fundamental rights. So first is Article 17, ठीक है? Then second is Article 21A. See, Article 21A was incorporated through 86th Constitutional Amendment Act 2002, which provides fundamental right to education. Okay, right to free and compulsory education to the children below the age of 14 years of age. Article 21A was added through 86th Constitutional Amendment Act 2002. Now, Article 21A states that, Article 21 stated that Parliament should pass law for enforcement of Article 21A. Now, Parliament passed such law under Article 21A only in 2009. Right to free and compulsory education, Act 2009. And this act came into force from 1st April 2010. So, from 2002, when Article 21A was incorporated as fundamental right, till 1st April 2010, Article 21A was not enforceable. समझ में आया? वो enforceable कब हुआ? जब पार्लियामेंट ने ये एक्ट पास किया 2009 में, जब, and that act came into force from 1st of April 2010. So from 2002 till 1st April 2010, fundamental right to free and compulsory education was mentioned in the Article 21A, but it was not capable of enforcement because it was dependent on this law to be passed by the Parliament, which was passed only in 2009. Example of non-self-executory fundamental rights. Similarly, there are other two fundamental rights under Article 23 and Article 24. Read the content. Article 23 prohibits trafficking in human being and forced labor, begar and similar forms of forced labor. Article 23, right against exploitation. Article 24, right against exploitation. It prohibits employment of children for work in factories, mines and any other cases of hazardous employment. ठीक है? Right? Now both this Article 23 and Article 24 required Parliament to pass law. And for example, in case of child labor, Parliament enacted Child Labor Prohibition and Regulation Act in 1986. Okay, right? Similarly, for this Article 23, forced labor, contract labor, forced labor abolition act was passed, I guess, in 1980. So Article 23 and 24 are also example of non-self-executory fundamental rights. Fundamental right तो है citizens पे, लेकिन अगर किसी ने child labor employ किया तो punishment क्या होगा, उसके लिए parliament ने law pass करना है, और law pass किया 1986 में. So what are the examples of non-self-executory fundamental rights under Part 3 of the Indian Constitution? Article 17, Article 21A, Article 23 and Article 24. These 4 fundamental rights are non-self-executory fundamental rights. Rest of the fundamental rights, they are self-executory fundamental rights. Okay? So which are non-self-executory fundamental rights in India? Article 17, abolition of untouchability. Article 21, right to education. Article 23, prohibition of trafficking in human being and forced labor, beggar, etc. Article 24, employment of children in hazardous factories, mines, so on and so forth. And all other rights are self-executory fundamental rights. Okay? So self-executory fundamental rights are those fundamental rights which are capable of enforcement or execution on its own. They are capable of self-enforcement, self-execution, without depending on subsequent legislation to be passed by the legislature. And non-self-executory fundamental rights are those rights which are not capable of their enforcement their enforcement or execution on its own. They are always dependent on subsequent legislation to be passed by the legislature. Now last but the most important point I am telling you. Now such law for enforcement of non-self-executory fundamental right, it can be passed only by the parliament and not by the state legislature. It can only passed by the parliament, not by the state legislature. It is mentioned in Article 35 of the Indian Constitution. Any law, any fundamental rights which is non-self-executory fundamental rights, they can become enforceable only when subsequent legislation is passed by the legislature. Such legislation, such law can be passed only by the parliament. It cannot be passed by the state legislature according to the provisions of Article 35. Clear? So today we have discussed the basic concept of rights, fundamental rights, classification, difference between legal rights and constitutional rights, fundamental rights and other constitutional rights, right? And we have also discussed about threefold classification of fundamental rights. Number 1, classification on the basis of content or subject matter. On the basis of that, fundamental rights are classified into 6 categories. Second, classification on the basis of availability. Some fundamental rights are available only to the citizens. Article 15, 16, 19, 29, 30. And other are available to both citizens and non-citizens. And third way of classification is to classify fundamental rights into self-executory fundamental rights and non-self-executory fundamental rights. Non-self-executory fundamental rights are fundamental rights under Article 17, under Article 21A, Article 23 and Article 24, and all other fundamental rights are examples of self-executory fundamental rights. Alright, so in the next lecture we are going to discuss about salient features of fundamental rights, and then I am going to discuss one by one. Article 12, 13, 14, all the articles I am going to discuss comprehensively, because fundamental rights is a very important topic. It is a core topic for UPSC, for both prelims and mains. And I told you that UPSC has some bias towards some topic. You know, they like some topics like basic structure doctrine, fundamental rights, preamble, directive principles of state policy. So that's why many questions they revolve around these 4 topics. Okay, so please prepare them well. Okay, thank you all of you. See you tomorrow.